Has been a while. Yes, I'm excited. The topic
Right?
is great,
It
so
is a really
very
great topic.
engaging. Mhm.
100%. With that, it's 5 o'clock. Our viewers on Zoom are starting to roll in. We're live streaming on YouTube. So with that, let's just jump right into it. So,
Perfect.
everyone, welcome to Family Law Now After Hours. Today's topic is common mistakes divorcing couples make and how to avoid them. Please note the purpose of this series is to discuss general information on separation, divorce, and family law matters. Any information provided here should not be construed as legal advice. If you're joining us via Zoom, please go ahead and use the Q&A feature to submit any questions or comments you may have throughout our webinar, and we will definitely do our best to get to them. However, if you are on YouTube, we're not going to be able to address any questions or concerns you may have because you don't have access to the function. So it's only a function that's available to those watching via Zoom today. If you have questions regarding your specific matter, we always recommend that you please either call our office or a lawyer in your area to book a consultation to receive specific tailored advice. And as always, stay tuned until the end as we will be sharing how you can schedule a free initial consultation with one of our lawyers here at Russell Alexander. Now to introduce my co-host for today, Miss Darla Weir, managing law clerk here at Russell Alexander. She brings extensive experience in family law and a client-focused approach. She prepares court pleadings, financial statements, and support calculations, keeping clients informed and supported throughout their entire process and throughout their case. Recognized as a family law expert, Darla retired from teaching at Durham College in 2021, and in her free time, she enjoys family, traveling, and participating in charitable fundraising.
Great.
Myself, I'm a family lawyer
Thanks,
here at the
Joseph.
firm. Oh, no problem. Myself, I'm a compassionate family lawyer here at the firm, driven by a deep desire to support families through challenging times. And with a background in commerce, I bring strong negotiation, analytical, and critical thinking skills to my legal practice. And during my articling period, I gained confidence in handling a wide range of family law matters, and I emphasize active listening, clear communication, and empathy, fostering a comfortable environment for clients. I am certified as a collaborative lawyer with the Ontario Association of Collaborative Professionals, and thus I offer clients an alternative dispute resolution approach to avoid court when possible. Outside of work, I am a dedicated Toronto Maple Leafs fan, 1-0 in round two, which is great to see, and an LA Rams fan, and I enjoy playing hockey and watching comedy movies. So, with that, let's dive right into today's topic. So, our first discussion point for the day, um, it really circles around the idea of clients making, or I should say, avoid making impulsive choices based on anger or resentment. And I feel as though this is a topic that we often speak of or we often come across. And what clients seem to forget, or I mean, in the heat of the moment, they don't necessarily recognize, is that family law decisions must be grounded in logic and evidence and not emotion. Right. Courts prioritize the best interests of the child and equitable outcomes. And decisions made in anger more often than not undermine credibility or create irreversible legal consequences, as I'm sure you've seen in countless
Mhm.
files that you've been involved in with Russ and
Mhm.
any of the lawyers here at the firm. And what I often find and reiterate to clients is that emotional decisions can result in prolonged litigation. And by refusing a reasonable offer or escalating conflict without a legal basis may increase costs, delay resolution, and affect judicial perception, which we don't want. We always want the judge to be on your side, to be agreeable to your position, right? So doing anything that can affect that perception is not ever really in your best interests. Um, More often than not, impulsiveness can damage your parenting case, I often find. Emotional outbursts, rash decisions, for example, parents who seek self-help remedies and withhold access or parenting time, if they refuse communication with the other parent, that very much can be construed as being uncooperative or not acting in the child's best interests. And there's a test that we actually look at for the child's best interests. It's found both in the Children's Law Reform Act, which is Ontario provincial legislation, as well as the Divorce Act, which is federal legislation. And clients say, well, how can I avoid making these impulsive choices? How can I do that? And the solution I more often than not tell clients is use your lawyer as a buffer. That's the one I really try to stress the most. And I often tell clients, before reacting, right? Before responding to that quick message that you got on Our Family Wizard or a sly communication you received via text message, before reacting, speak to your counsel about the legal strategy and consequences, right?
Mhm,
Emotions can be acknowledged, which is it's valid, that's fair, but
mhm.
they cannot be the premise for you dictating your legal position.
Correct. And if
Right.
I could just add to that as well, Joseph,
Please.
don't ever use the children as leverage.
Mhm.
Like as you said, keep it in the best interest of the children or child. You want to be child focused with decision making and parenting time. You don't want to ever use the children as messengers or pawns. Um, in the end, the court would really frown upon that behavior. Let the kids be kids. Like you have brought these children into the world, and it's your responsibility to parent them in a healthy environment. And it's not healthy to draw them into the litigation. That's an adult matter. That's not a child matter. So just, keep in mind that you need to always think about what's best for them and don't put them in the middle. Don't, like let the kids be kids. Don't, you know, have them in a situation where it's not healthy for them.
And I'm sure, Darla, you've seen, like I've seen it in person in court, but you as a law clerk, I'm sure you've read
Mhm,
endorsements of judges or decisions and
mhm.
them chastising parents who do that. And it's really of no
Yes.
benefit to your case, right?
Mhm, definitely. Like you need to, um, obviously you always want to draw upon the advice you're receiving from your lawyer. If you're not taking your lawyer's advice, the lawyer could consider that at some point a breakdown in your child's or in your solicitor client relationship. And that's only going to escalate costs for you as well. Just as if you're, not remaining child focused and there's a lot of negative emails going back and forth. Um, eh, and I know it's very difficult because it's very emotional. Like, obviously, these are your children and you want what's best for them. And, in a lot of cases, people don't anticipate that they're going to be separating from their spouse. And, there's a lot of the emotions are high, but you want to make sure that you're um, taking the legal advice from your counsel and keeping it child focused. Because ultimately, like, that's going to save costs as well.
100%. And I mean, another, I would say, sorry, excuse me, another mistake that clients, when they come into the office, they don't necessarily know or fail to understand their finances. And sometimes it's the case where there's been financial abuse, which is understandable, and then we take the necessary steps to overcome what's, transpired in the past and how we can work towards financial freedom in the future and making sure that financial disclosure is paramount in your family law case. But for those who were not necessarily susceptible to financial abuse and they had a pretty good understanding or at least were actively involved in the controlling of finances throughout the relationship. Um, Not knowing your financial standing can more often than not lead to unfair settlements. So, what I like to tell clients is that number one, disclosure is mandatory in family law. Um, Under what's called Rule 13 of the Family Law Rules, full and frank financial disclosure is required, and failing to understand your own finances can lead to agreeing to spousal support or even child support terms that are either unsustainable or unfair because they're not supported by the actual disclosure or the actual income that's being received by either party. Another issue that results in individuals failing to understand their own personal finances or their marital finances if they're married, or even if they're in a common law relationship, understanding that maybe some of their assets may be joint or solely held, and the differences between the two. Some people can waive entitlements unknowingly. Um, it's really important that there has to be full clarity on the other person's or the other party's disclosure in terms of their overall financial health. And that means without clarity on, for example, pensions, whether or not they have pensions through their employment. Maybe they have RRSPs or TFSAs, other investments, maybe real estate holdings, both domestically and internationally, that you may or may not be aware of, business interests, um, debts, even. Debts is a large one that people sometimes, when they go through this disclosure process, they're like, I didn't know we had a line of credit through Scotiabank. I didn't know we had a credit card with Amex. A lot of questions start to pop up, right? So without clarity on these things, you give up significant equalization rights, or you at least are at risk of giving up significant equalization rights under Part 1 of the Family Law Act. So it's really important that you do not engage in settlement discussions without having a full, clear picture of the other person's finances. Another thing that often pops up is that hidden liabilities, so any debts or assets can come back to haunt you, right? So for example, if your former spouse has incurred debt in joint names, right? Because the fact that debt has been incurred jointly, there's a legal basis for you to be liable to those debts. And if you agree to a settlement without understanding this, you assume the risk. So
Mhm.
one potential or one example would be, for example, is a joint mortgage on the matrimonial home. And more often than not, parties engage in discussions regarding a spousal buyout. And one party might be agreeable to the other spouse buying out their interest, which is, totally okay. But they don't engage the process of refinancing the home solely under their name. And then what happens is that even though the one party has sole title, the other spouse who sold off who had their interest bought out, they still remain on the charge, and they're liable for that. So knowing these things is really important. Um,
Mhm.
and
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 work
really
work with your legal team as well.
100%.
Like, the law clerk is there to help you um, assemble and arrange all of the disclosure. It's better to give the law clerk more information than
Mhm.
less information, because our law clerks are very knowledgeable, and they are experts at sifting through all of the information that you might provide, and giving to the lawyer what they need to make sure that all of that disclosure, as Joseph is speaking of, is provided, exchanged with the other side, and you have an accurate financial statement. The financial statement is a sworn document, so you're swearing that the contents are true, and you want to make sure that you've provided all of that information to your legal team so that they can complete that document accurately for you.
100%, Darla. And I know you previously spoke to it about the implications or the consequences of ignoring legal advice. Can you maybe
Mhm.
touch on that a bit more and really expand on how following, the guidance of your clerk or your lawyer can really help prevent costly mistakes?
Sure. Well, don't, again, full disclosure, as Joseph has said. Um, don't feel that, oh, they might not need this, or I just won't mention this because no one will know about it. Eventually, it comes out. And that, if you're in court and you have hidden disclosure from the court, you could be subject to court costs. It will also escalate the costs, your legal costs with your lawyer, if they're not receiving all of that information right at the beginning. Uh, if you haven't provided full financial disclosure for a separation agreement, then down the road, and Joseph can speak to this further even, down the road, that separation agreement may be set aside and considered to be invalid because you haven't provided all of the financial disclosure that you were to provide. So the consequences are great. Like that, it can result in your file even going on longer than it needs to if you haven't provided the disclosure and you had a court date and then the court gets adjourned to a further date so that you can then provide that disclosure, it could be months away. Like we all know that the courts are very, very busy, and you want to be dealing with things right at the beginning in the correct way. And the correct way is to provide everything to your legal team, and then we'll go through it. And that will save you costs and time in the end.
100%, darling. I couldn't have explained it better myself. Um, another topic that I'm gonna get into, and I often see results actually a lot more frequently than I would like, is that either clients or even the opposing party um, are actively posting on social media about what's transpiring and their separation process. And I wouldn't think to myself why someone would actually want to do that, why they would want to make something private and intimate known to the general public. But alas, people like to share. And I
Mhm,
mean, what's really, the critical point is that anything shared online can be used against you in court. That's something that really should be known to everyone watching here today or can be watching in the future.
mhm.
And the courts do accept social media posts as evidence, right? So if
Yes.
there's posts that demonstrate hostile behavior,
Mhm,
they demonstrate attempts to alienate the other parent. Sometimes there could be financial misrepresentation. For example, I've seen it where on someone's financial statement, it just notes that they have, uh, a Honda, and then next thing you know, they're posting, "Oh, I'm on my boat in Lake Ontario for the day.
mhm,
I'm, having a boat party," and
mhm,
why wasn't that boat disclosed as something that you own? So I mean, it can
mhm,
work really against you.
mhm.
So,
It
you
can
know,
also go against your credibility.
100%.
I have a bit of a funny story. We had a client one time that um, knew that her ex-partner had, um, kept some family heirlooms, like things she had received from her grandmother. And her ex-partner was adamant, no, 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 I don't have them. I would never do that. I would never keep your grandmother's heirlooms. Well, then pictures were posted of him in his home, but in the background on the like a china cabinet was our client's grandmother's heirlooms. And I'll never forget that as an example that, you know, be firstly, that went right against his credibility because he swore affidavits that he didn't have it and he did have it. And then posting it on social media for the world to see, like that was obviously, I think the judge even ordered costs against him for that because we could prove he did have them, right? And but even as you had mentioned, setting aside like the materialistic things like that, if you're posting things that, involve your children, like think about your kids too. Like a lot of kids today they grow up pretty quickly and they're also on social media. And you don't want to maybe have your young teenage children having access to something that you've posted against their other parent. Like I think people, just need to, um, I always say take the high road Like, think about like what you're going to do and what the result of your actions are going to be before taking those actions.
100%. And I mean, you know, in relation to what you just said, right? Like, um, any derogatory or aggressive content, right? It really affects parenting evaluations. And
Mhm,
if a court is going to do an assessment and they're going to see conduct or assess conduct that impacts the best interest of the child,
mhm,
those negative posts are going to undermine your position. Maybe you're looking for a reason why you're an active father and that you can work with the other spouse or the child's mother in a child focused and effective manner. And then you go ahead and start posting all these things on social media saying she's this, she's that, etc.
mhm, mhm,
It's not going to be in your favor, right?
mhm.
So
Right.
and some people tell me, oh, like don't worry, my Instagram account is private. That's what
Mhm.
I get the most, right? And what I tell
Yes.
people is that even private posts aren't public, and there's a lot of case law and uh, decisions that quite frankly spell out that opposing parties can actually subpoena content or they can receive screenshots from mutual connections.
Mhm,
And courts have previously admitted these posts, in parenting matters. So I mean,
mhm.
even if your wife or your spouse is not a friend of yours on Facebook or is not following you on Instagram, maybe someone they know is. And they can very
Yes.
well get those screenshots just as easily as she could have or they
Mhm,
could have. So
mhm,
a solution I tell everyone is that assume everything is public. Don't post about your case. Don't post about your ex-partner or even
yes.
vague references to the proceedings. Just avoid
Mhm,
emotional venting online, period. What
mhm,
I tell people is document your concerns privately and through legal channels. That's the
mhm,
best way to overcome any
mhm.
issues.
Yeah.
Um,
And try not to ever like refuse to compromise, especially you know, when you're talking about the finances, as long as all the disclosure's been provided, that's pretty black and white. But your children, um, like, try to be a little bit flexible with each other. You have years of parenting these children, um, and it's going to be better for the kids if they feel that their parents can show some flexibility to compromise, especially if you're talking about a parenting schedule. Maybe one parent, it's not their weekend, but they have a family event. Like, work together in the best interests of the children. And having that flexibility is, in the long run, again, going to be best for everyone. I know it's easier said than done, like, in a lot of cases, um, there's reasons that, it's a very emotional time. And, you just have to try and always put the kids first and think about what's going to be best for them. Yeah. Well, I'm sorry, Joseph,
I'm
you're
muted.
muted.
Yeah, thank you. 100%. What I tell people is that being unreasonable and being inflexible can lead to longer, more expensive legal battles, something no one wants. And when I
Hmm.
tell people the cost of a trial, their jaw drops. So, going
Hmm.
going for a simple case conference can range between $3,000 and $10,000, and that's just for one appearance.
Hmm.
So you
Hmm.
multiply that by the three or four that you have, plus if there's motions, a motion can range, at the very least $8,000 to $10,000, depending on
Hmm.
how many issues we're arguing. And then we get to trial. Trials probably cost between, depending on the number of issues and the number of days, easily between 45 to 100,000. So I mean,
Yes.
it's in your best interests to keep an open mind and be reasonable.
Hmm.
Um, Darla, um, aside from all the legal stuff we've been discussing today, um,
Hmm.
maybe more on a personal note, can you maybe
Hmm.
speak to the fact that sometimes people neglect self-care and mental health
Yes.
and how
Yes.
they can overcome that?
Very good point, Joseph. You want to make sure that you're well yourself to care for your children or whatever the case may be. And it can be a real strain. A separation can be a real strain on your mental health, your physical health. There are many services available out there. Don't be afraid to utilize them. Perhaps your employer has an EAP program and you can um, receive counseling or therapy through employment. I know our office also has recommendations. If don't be afraid to reach out to your legal team and they can provide you with recommendations to go and speak to someone as well. That's very important. Your mental health is at the forefront, and you want to make sure that you're well so that you can be a good parent and make, those decisions that are going to be good for your family and your children for the future. So don't neglect your self care or mental health. Reach out to, uh, again, there's many options to reach out. So don't be afraid to do that. That's really important.
No, well said. I mean, oftentimes people always are afraid to do so. And then,
Mhm.
out of the most stressful times in one's life, and there's a lot of studies done on this. The first is being losing a family member or a loved one.
Yes,
And then the second most stressful time in one's life is divorce and separation.
yes.
So I mean, what you're feeling, what you're going through is not novel. It's not unusual. Everyone
Mhm,
goes through it, and it's
mhm,
just about how you manage those feelings. Because if you're in a state that's affecting your mental health negatively,
mhm,
that's not going to allow you to be as actively involved and clear-headed in this process as you want to be.
mhm,
More often than not, when your mental health is addressed and you're in a position where you're emotionally stable and you're less stressed out about what's transpiring, having a clear head allows you to make rational and reasonable decisions, which in the end will save you a lot of time and money. So it's really important
yep,
to address the mental health aspect of what you're going through because, to yourself, it might be, a minuscule or a minimal event or even the process itself might be minimal, but it really has significant impacts down the line. And
mhm,
speaking of looking at significant impacts down the line, um, it's really important that when people are at the stage in the process when they're entering into agreements, it's very important that they do not overlook the long-term impact of their decisions. And again, sometimes they do so when they're in a poor mental state. So it's really important that you consider how agreements will affect your future and not just the present. And
mhm,
if I can speak on that a little bit, um, with respects, for example, to the equalization payments and support. Both of those things have long-term effects. And
yes.
agreeing to a lump sum payment or a spousal support buyout without tax or future income considerations may be detrimental to you. So it's really
Mhm,
important to look at your financial state now and see if the agreement is going to hurt you financially or not put you in a position to be financially stable, you know, 3, 5, 7, 10 years down the line, right? And that's just a financial aspect. We have times and issues when we're dealing with parenting plans, and
mhm,
we have separation agreements that contain parenting plans or parenting terms, but they don't anticipate growth and change, which is
mhm,
basically a recipe for having to come back and being a repeat customer to the court system. And it's
mhm,
really important that agreements or any domestic contract that deals with parenting really has a rigid plan that doesn't account, um, or I should say, a rigid plan that doesn't account for evolving school schedules, extracurriculars, or future relocations will need frequent variation, which we don't want repeat customers in family law. We
mhm,
want to make sure we
mhm,
get things done right the first time, and we can avoid any potential amending of an agreement or bringing a motion to change the litigation. We want to limit that as much as possible. So really, um, having these agreements that anticipate foresight and growth and change is really important.
And if I could add to that as
Yeah,
well,
please.
Joseph, usually we try to add in our agreements dispute resolution clauses. So they allow for, that how are you going to deal with down the road if there is a dispute with perhaps without having to go back to court. We usually have the mediation clauses built into the agreement. And actually, we had an order not too long ago at court that we built in the mediation clauses within the order. I'm not trying to take business away from the firm because, you might find you do need a lawyer anyway, but mediation can be a cheaper option that, avoids you going back into court, which is very stressful, very expensive. You are never guaranteed the outcome
No.
because, you could be uh, the decisions then, or if it goes to trial, then it's a trial judge making the decision for you, not for your family. So I mean, like you are not able to make what you feel is perhaps the best decision
Mhm.
for you and your family. A trial judge is going to make that decision. So we build in those clauses for mediation. And I know, as Joseph mentioned at the beginning, Joseph is a trained collaborative lawyer. So that's another option as well, that to avoid going through court, you can go through the collaborative process where a family professional, a neutral family professional, is retained to work with the as a team for the children or communication. Financial professional is also retained to work jointly with the parties to go through all of the financial disclosure. So that's also another option. If you're, which should be relatively not as stressful a situation as going to court. Right.
100%. It's
Mhm.
so funny you say that because now whenever I do like a final minutes of settlement, I always incorporate a dispute resolution clause. And
Yes.
more often than not, the opposing counsel doesn't have issues with it. Like they
Mhm,
welcome it. So
mhm,
now I try to really in all final orders, I have dispute resolution mechanism, which more often than not deals with mediation arbitration, but still it's a great
mhm.
tool. And I think it should
Absolutely.
I really think it should be the basis and the common practice and a standard boilerplate, quite frankly, of all final orders, and that
Mhm.
people don't actually come back to court, and that there's a mediation component, or at
Yes.
least a mediation arbitration component.
Mhm, mhm,
And just going back to dealing with, overlooking the long-term impacts of decisions. Um, two more things I just really want to touch on. One being the failure to protect against future disputes, as we've sort of briefly touched on, but
mhm,
vague language in separation agreements or any other domestic contracts leads to interpretation battles later on. We don't really like that. So
mhm.
what I normally tell clients is that specificity today avoids litigation tomorrow. So being
Yes.
as concise and removing any ambiguity is really important. And
Mhm,
what I tell clients is that when they're looking at this decision that they're about to make, after I've provided my legal advice, I tell them, look at this agreement we've drafted. Now put on your glasses and look at it through a 5-year lens.
mhm,
So in five
mhm,
years, am I gonna like the agreement that I've come to today? Right. So
mhm,
I ask my clients, what happens if if you lose your job? What happens if your job changes? What happens
mhm,
if you're in a different field? What if your ex-partner remarries? Right?
mhm,
What if your child needs special supports down the
mhm,
line? Right?
mhm,
Agreements must be forward-looking not
Mhm.
just reactive. So I really emphasize a proactive approach because I find more often than not in family law, especially in the litigation realm when we're in front of judges, judges are not really proactive, they're reactive. And
Yes.
I think it's really important to be proactive.
Hmm. Excellent point.
All right.
Excellent point, really. Because, and I know it's hard. Nobody really knows the future, as you said. You don't know, like, if you're going to have job stability or uh, um, your children, if they'll need extra care. So that is really, really good advice to do that for sure. Hmm.
100%. And then Darla, maybe you can speak to an issue that clients more often than not do make, and that's, failing to update, any legal or financial documents that they may have or have
Right.
interest in.
So it is very, very important to make sure that you update all of your legal documents, your will. And Joseph can speak to this better as a lawyer, but you wouldn't want an existing will, um, personally, or I wouldn't want my estate going to my ex-husband just because I didn't update my will. So you want to make sure you do that and your insurance and your beneficiary designations as well on your insurance. However, we generally don't recommend you update your beneficiary designations until you do have some final form of agreement. So, just be mindful that there are those other legal documents that you should be thinking about. First and foremost, I would say get your will updated. And maybe Joseph can give a better timeline of when to do your actual beneficiary designations, because I know
Yeah,
sometimes we like to wait until the matter has been resolved with respect to support payments.
for sure. I mean, the one big one that just, strikes out to me is life
Mhm,
insurance proceeds.
mhm,
And then more often than not, as you mentioned, as it relates to support, the payor, so the person who is paying the child support to the recipient, or the payee, they'll have an obligation to pay child support, and then more often than not, we use life insurance as a means to secure those obligations. So, quite frankly, we see, or what we do is that we actually have the payee or the recipient be the beneficiary of those life insurance proceeds, or at least a portion of the life insurance proceeds. So it's really important just not to play around with it too much until we have a legal, formalized agreement, or it could be court order, something that
mhm,
we can you can use, and then once we have that, we can take that and say, hey, under paragraph 26, you have an obligation to irrevocably designate your spouse as a beneficiary on your life insurance policy. Go ahead and take care of that.
mhm,
However, I will say with the wills, as soon as you have an intention of wanting to separate,
mhm.
that is when, in my head, I would start to, move in the gears towards, hey, if I already have a will, it will
Mhm.
need to be updated, because I can assure you, when you did your will previously, your current intentions have changed drastically, as Darla
Yes.
mentioned. So
Mhm.
that's when you should start having that conversation. You should be speaking to a wills and estates lawyer about getting that process undergoing. I mean, the wills and estates lawyer may advise accordingly. They may want to wait for a separation agreement,
Mhm.
before any substantial changes are done to a pre-existing will or the drafting of a new one. It may be as simple, if you don't have a will, is having something very simple done on the outset, and then either doing a codicil, which is an amendment to a will. There's
Mhm.
different ways to go about it, but as soon as your current intentions deviate from what you've previously communicated via a will, it's time to revisit that. So those are just a
Correct.
couple of those things.
Mhm. Mhm. Oh, bless you. Yes, and I think too as well, like with the beneficiary designation, if you have an obligation to pay child support or spousal support, then you do have usually incorporated into the order or the agreement is the language that Joseph spoke to ensure that that obligation is being, I guess, offset or taken care of by a life insurance policy. Mhm.
Perfect. Thanks,
Yeah,
Darla.
yeah.
And finally, I think the last point that I sort of want to touch on is uh people rushing to settle without proper review, right? It's really important that people take the time to fully understand all the agreements and the terms of those agreements before signing.
Mhm.
So, a signed agreement is presumed to be binding, right?
Yes.
So, unless successfully challenged on narrow grounds, which there are grounds to do so, lack of disclosure or material non-disclosure, duress, unconscionability, courts will enforce family law agreements,
Mhm.
right? So, what does that mean? It means independent legal advice is essential. And
Mhm.
independent legal advice ensures that you understand your rights and obligations and the implications of the agreement. And quite frankly, without it, your ability to set aside a bad deal is greatly limited.
Mhm.
I tell people that rushed settlements often miss critical components. When you're in a rush, people forget to address the little things, for example, such as RESP contributions, Section 7 expenses, tax
Mhm.
deductions, or even sometimes
Mhm.
pension divisions. And that leads to severe
Correct.
gaps that are not addressed. So a solution I quite confidently impose to clients is that you should be insisting on a clause by clause explanation. So
Mhm.
do not sign anything until your lawyer has gone through every provision with you, paragraph by paragraph, even if there is external pressure. Settlement is extremely valuable, but not at the cost of fairness or legality for that matter.
Yes.
So
Mhm.
if your lawyer wants you to rush through an agreement, don't do it. Make
No.
sure they go paragraph by paragraph, clause by clause, and make sure that you have a good understanding of what that clause notes and what your rights and obligations arise from that clause.
Mhm.
It's really, really important.
Mhm. And if you have like a 10, 15, 20-year marriage, it takes you time to unravel that. You can't just expect that, oh, my 20-year marriage, I'm just going to have a separation agreement. A red flag to me would be, oh, we'll sign a separation agreement within a couple weeks. Like it takes time to unravel those finances and make sure that, all of the T's are crossed and the I's are dotted and all the disclosure has been exchanged. You don't want something to be missed. And then at risk, as Joseph said, down the road, that could be detrimental. It could be detrimental from a support point of view, from an equalization point of view, like take the time to unravel um, the marriage in a sense to make sure that you're doing everything properly and getting all of the information that you require.
100%. And with that, that actually is a great way to close out
Mhm.
today's webinar.
Sorry, the sun. It's just,
It's
I tried. I kept trying
Darla,
to
you've been
move.
you've been you've
I
been
have
golden hour. You've been
I
golden hour since 5 o'clock.
know, like a halo. I've had my blinds closed, but clearly they're not working.
Golden hour. Um, Everyone, thank you so much for tuning into Family Law
Yes,
Now.
thank you very much.
Following the session, if you are viewing us via Zoom, a brief survey will appear, allowing you to share your comments and suggestions for future topics that you'd like us to explore. And as always, your feedback is greatly, greatly appreciated. For those that have stayed till the end, please book now to take advantage of this opportunity for a complimentary consultation with one of our lawyers here at the firm, Russell Alexander. In order to do so, please contact our intake team at intake@russellalexander.com. It's two S's, two L's, and provide the code NY 2025. That's NY 2025 to schedule your appointment. In order to do so, you have to do it by this Friday, end of day. Your initial consultation does not have to be by Friday, but you have to schedule your appointment by that date. Registration is also now open for the next event, Protecting Your Mental Health During Divorce. And all you have to do to register is go to russellalexander.com/family law now. Thank you to our panelists. Well, today is just a singular panelist, but thank you, Darla, for sharing your insights today. You're so knowledgeable, and whenever you
Thank
speak, I
you.
learned from you, and I'm sure everyone else viewing today learned a lot from you today as well.
Thank you, Joseph. It's my pleasure. Thank you.
And as always, thank you, the viewers, for tuning in today for Family Law Now After Hours. And it is officially after hours. So with that, I wish everyone a good night and thank you for tuning in.
Have a good night, everyone. Thank
Thank you.
you. Bye.